Hello and welcome back to Fin 340 Real Estate. Today we'll be talking about Chapter 4, the fourth part of Lecture 1. So this chapter mainly deals with who owns what with respect to common and joint tenancy and tenancy by the entirety. So sole ownership or ownership in the severalty, okay, severalty or severalty, okay, means actually that they're severed, okay. So they're not several owners, but severed owners, individual owners. These people are regarded as individual owners of the entity where they have full right in the entity, but they can sell that right in the entity. Married individuals are considered one legal entity with respect to ownership in the severalty, but they as married couples are not considered individual separate owners, but they are considered a single legal entity because when you get married, you become a single legal entity. If they had other people who are owning the property with them, then they would be owners in severalty, and the married couple would be regarded as one single entity, and the other individual or other married couple would be regarded as another legal entity. Businesses can also own property in the severalty. Sole ownership of the severalty in the fee estates allows for the complete control of the property and the flexibility that it creates with it. So they basically can make any and all decisions with the property, okay, if you have sole ownership. Okay? So that's the key there. They don't have to agree or get anybody else's signature for anything. Tenants in common is where there is more than one party in ownership. So it's not ownership in the severalty, it's more than one party in ownership, and this is the case where we had another married couple owning a property with another married couple. This would be tenants in common, okay? Or two individuals, it doesn't matter, as long as there's two or more legal entities which exist in this ownership of the property, they can be called tenants in common. Okay. Now, tenants in common has a difference with respect to joint tenancy, so we have to keep these two separate here. Ownership interest with the individual owner has full rights over the entire property. They have undivided interest, and usually in court documents or tort law, you will see it says they have undivided interest, and that means tenants in common. They may not say these are tenants in common. Deeds say tenants in common, but court documents say the individual parties have undivided interest. Okay, so you have to be very careful with what that means there. Okay, words of conveyance is with respect to the deeds, they will say as tenants in common. So Jane Doe and Bob Dylan, whoever it is, are tenants in common, which means they own the property together. Okay. And they have no indication of division of the ownership, then it is assumed that the rights of ownership are split equally. If the deed says that one individual owns more than another, then the percentage of those rights are written in the deed as well, and those individuals have rights of ownership in the deed. Okay? Rights of survivorship are not automatic when it comes to tenants in common, and this is the key difference with respect to joint tenants. So rights of survivorship do not exist in tenants in common. Survivorship means that the other owners of the property who are in common do not automatically become the further owner of the property if the one individual dies. So if I got two owners and they are tenants in common, if owner A dies, owner B does not automatically begin to own owner A's rights. In fact, the heirs of owner A are the ones who now own that right. Okay, so basically there is inheritance that occurs when there is no right of survivorship. The right of survivorship allows the remaining owners of the property to subsume the ownership of the now deceased owner. Okay, so debt reclamation and other items also do not transfer as a right of the entire property, only in the interest of that divided property part. Okay. The owners of the property are co-owners, so if they derive a revenue from the property, it has to be split evenly or according to the percentage of ownership, but also all costs associated with the property are split evenly or divided by the percentage of ownership. And that includes property taxes, repairs, upkeep, and etc. If one owner does not pay their costs or property taxes, the other owners must pay those costs or property taxes and can sue the remaining owner for their portion, okay? In order to participate in those costs. Joint tenancy is the ownership that is held of the full estate in the case that if one individual dies, the remaining owners who are alive, okay, are able to subsume and subsume that property right. It does not automatically move to the heirs of the deceased tenant. Okay, so joint tenancy has the key item that we discussed before. It has survivorship. Okay, so the owners of the full estate, if owner A dies, owner B becomes the sole owner of the property. Even if owner A has a son and owner A and B are not married, then owner B becomes ownership of the full property, regardless of the fact that owner A had a son. Okay? For joint tenancy to exist, you need unity of time, unity of title, unity of interest, and unity of possession. Okay? Unity of time means that the ownership must be struck at the same exact time. You cannot create joint tenancy at another time than purchasing the item or striking the joint tenancy of ownership. Okay? Basically, you can't just give up the right to somebody else. Unity of title means that both individuals must be listed on the title agreement, on the deed agreement. Unity of interest is that both individuals or more than individuals in the joint tenancy have to have interest in the property. They must actually be owners of the property, and they must also be in real possession of the property. So you cannot be leasing the property, this is unity of possession. You cannot be leasing the property and expect to be a joint tenant. You must physically own the property through deed rights. Tenancy by the entirety is the case for spouses only, okay, for joint tenantship, which requires unity of the person. So unity of the person is just a fancy way of saying they are in fact married. So when you become married, you become one single legal person. Okay, so when you become married, you are a single legal entity. You activate unity of the person, and therefore joint tenancy becomes tenancy of the entirety. Okay, so basically, the wife gets everything that the husband owned in real property if it is joint tenancy by the entirety. Okay? If the individuals divorce, they enter what is called tenancy in common. So we revert back to tenancy in common. Effectively, each individual has their own rights in the property. It is split 50-50. So if you have ever seen divorces occur, you may read legal documents that say, oh, they received 50-50 of the rights in this property. And the reason is because they were joint tenants, and then when they filed for divorce, they became tenants in common. Okay, that is the end of the review for Chapter 4. It's a pretty brief chapter, but you should read more detail about the items that exist therein. Your discussion has a lot to do with this chapter.